Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. And tonight we're going to be discussing Chapter 4, Capacity to Commit Crimes and the Insanity Defense. And again, before we jump into this, just a quick reminder about those resources that are available at the end of each chapter, which consist of the definitions or the terminology areas, the true or false quiz, the short questions that focus a little bit more on some of the larger, more difficult things, if you will, that we're learning, so they can help you add some context to the conversations. And then, of course, the terminology matching quiz, which I think is a great way for you to study for your upcoming weekly quizzes or even your chapter exams. And also, don't forget about those scenarios or cases that are listed throughout the chapters that will also add some context to the overall subject matter that we happen to be discussing. So, excuse me, with that being said, let's jump right into Chapter 4 and talk about capacity of committing crimes. So, Penal Code Section 26 states that all persons are capable of committing crimes except those belonging to certain classes, or the following classes that we're going to actually talk about here. And those would be children under 14 with certain rules and guidelines: mental incapacity, ignorance or mistake of fact, unconsciousness, accident or misfortune, or threats of duress or coercion. Now, in addition to these, a victim of human trafficking who was forced to commit a crime may assert this fact as an affirmative defense, except as to serious violent felonies or a charge of human trafficking. So there's kind of an additional thing for us to consider. So let's start off with the first one, which would be children under the age of 14. Now, at common law, children were presumed mentally incapable to commit crimes. And California statutory law, however, basically says under 14. That refers to that chronological age, not mental age. All persons under 18 years of age are subject to juvenile court, and persons under 18 are still afforded similar constitutional rights as adults. And there's a famous case that goes with that, and it's the In re Galt case. So the common law rule regarding the criminal responsibility of children and the fact that they are conclusively presumed to be mentally incapable of committing any crime is completely non-existent in California, in the state. The age referred to in the California statute would be under 14 years, refers to chronological and not mental age. Again, all persons in the state who are under 18 years of age are subject to the provisions of the juvenile court, specifically penal law. The primary jurisdiction for criminal cases involving persons under the age of 18 rests entirely within that juvenile court system. And it is highly unlikely that a juvenile the age of even 16 years who has committed a crime less than a felony would ever be subject to the formal adversarial judicial proceedings, which are reserved for, specifically for adults. But this is not to say that children under the age of 18 are not given equal rights to adults. On the contrary, the Supreme Court, particularly in that In re Galt case, spells out the fact that juveniles are to have many of the same inherent constitutional rights as their elders. Now, the only difference really between juvenile adults, and there are a couple, but juveniles have no right to bail, nor do they have a right to a jury trial. So as we kind of keep talking about here, children under the age of 14, to hold a minor under 14 culpable to commit a crime, the law requires that the state prove a couple of things. The accused must have known the wrongfulness of the act at the time the act was committed. And there's a very important case in Re Gladys R. that talks a little bit about that. And in order to help officers or the judicial system figure out whether or not they knew about the wrongfulness of the act, if you will, at that time, would be some relevant areas of inquiry that include things like age or intelligence or education or experience. And these would be ways that you would be able to figure that out. The next on the list we'll talk about will be mental incapacity. Now, a person who is mentally incapacitated is defined as one who is virtually without mentality, one who is without understanding. This defense is clearly separate from that of an insanity plea and represents the defendant's mental status from birth. Such a person is said to be incapable of appreciating the character and significance of his or her acts. Now, the mentally incapacitated, as characterized by the Binet Intelligence Classification Scale, appears lowest on the scale, having been said to possess an IQ from 10 to 24. And finally, mental retardation does not generally fall into this area unless it can be shown that the defendant is incapable of knowing the wrongfulness of their acts. And if you're following in your textbook, these are all kind of categorized, subcategorized off, and it's an easy way for you to kind of reference them as we go through. So the next one on the list would be ignorance or mistake of fact. One who honestly and mistakenly commits or omits, doesn't act, lacking the mens rea, and we've talked about that, may introduce the ignorance as a defense. Now, this mistake must be of fact, not of law. Ignorance of the law is generally not a criminal defense or an excuse, and you've probably heard that phrase before as well. Mistake of fact lacks criminal intent, and if you want to know a little bit more about that, you can look at a very interesting set of facts that came together in the Dr. Samuel Mudd case. And in this case, Dr. Mudd was tried for aiding John Wilkes Booth after Booth's assassination of President Abraham Lincoln. And I don't want to, I know you're all on the edge of your seats wanting to know what this is, but I'll have you take a minute and review that. If you could Google Dr. Samuel Mudd, and it will walk you through the mistake of fact defense of this particular case. And it's actually kind of interesting. I think you'll enjoy it. So next we're going to talk about unconsciousness of act. And this relates to the lack of functioning of the consciousness of the mind. It has no reference to insanity or mental disease. And an example that we could give would be sleepwalking or fever or delirium, a blow to the head, involuntary intoxication. And these are some of those things that would fall under this unconsciousness of act. Now, the burden of proof is on the defendant in these types of cases to prove the unconscious state. Now, voluntary intoxication is not a defense when a crime is a general intent crime, and that's listed under Penal Code 22 subsection A. There's also a very famous case, and I believe I did post a video in the module under this particular chapter, chapter 4, where a husband basically commits murder. He kills his wife, and he ends up using sleepwalking as a defense. So again, really kind of interesting information, but remember, this has no reference to insanity or mental disease. It's the unconsciousness part that makes this different. Accident or misfortune? Well, I mean, you've all heard the phrase, accidents happen. Well, a defense under Penal Code 26, paragraph 5 is based upon the absolute lack of the requisites of a crime, meaning lack of criminal intent, lack of criminal act, negligence, or evil design on the part of the defendant. Now, such a defense is often offered in cases of homicide, either as excusable or justifiable homicide. So, for example, if a person were to drive a car within the speed limit and the child runs into the path of the car in pursuit of, say, a soccer ball, and the death of the child basically would have been unintentional with no evil design on the part of the driver, assuming that the vehicle was operationally sound and there was no negligence, this would be something that would fall under accident or misfortune. So kind of to summarize again, or to re-summarize, this defense is based on the absolute lack of intent or evil design on the part of the defendant. Such defense is often referred in cases of bodily injury or homicide cases, and the killing of a human being is excusable when doing an act by lawful means without unlawful intent, and we kind of went over that a second ago, and you could find that under Penal Code 195. And then finally, threat, duress, or coercion. Now, when a person is forced to commit a crime because of threats or menaces sufficient to show that such person had reasonable cause to and did believe their life would be endangered if they refused, they may be able to use this defense provided by Penal Code 26 in paragraph 6. So, thus, when one forces another to rob a liquor store with an unloaded gun by threatening to shoot the perpetrator if he fails to comply, the innocent perpetrator who committed the crime under threat of certain death would not be responsible for the commission of a crime. Also, threats of future danger of loss of life is no defense. The danger must be real and immediate. So, again, this defense may not be used if the crime is punishable by death, and the social policy is that you may not take a life to save your own. The exception, again, is self-defense. So there's a couple of famous cases there, but let me back up and go through this one more time so we kind of all got it, and then we'll talk about this other famous case. So Penal Code 26, Section 6 allows the accused to use the defense of threats, duress, or coercion if they had reason to believe their life was in fact endangered. And we already heard that that threat of future danger or loss of life won't work as a defense. The danger must be real and it must be immediate. This defense cannot be used if the crime is punishable by death. The social policy is that you may not take a life to save your own. The exception would be self-defense. And the famous case that we can kind of look back to would be to review the case of Patty Hearst, the wealthy heiress who was kidnapped and then became an aider to the group's criminal activities. So we won't spend a lot of time on that case, but it would be kind of cool for you to go back through and look at that case as well. Well, so now that we talked about those things that fall together under Penal Code 26, let's now look at insanity as a defense, because I think we've all seen this in the movies, or we've kind of heard it one way or another, but we're going to kind of dig into it a little bit deeper. So the purpose of a legal test for insanity is to identify those persons who, owing to mental illness, should not be held criminally responsible and so punished for their crime. The question then kind of comes about, well, what really constitutes insanity? So we know what the purpose is, and now we're just trying to kind of figure out, well, what really constitutes it? Well, Penal Code 25 subsection B states that it needs to be proved by the preponderance of the evidence that the defendant was incapable of, one, understanding the nature and quality of the act, and two, distinguishing right from wrong at the time of the act. So let me go back and define a little bit further under that Penal Code section 25B. Under Proposition 8, the test for legal insanity is now whether a criminal defendant proves by the preponderance, greater weight or majority of the evidence that he or she was incapable of, one, knowing or understanding the nature or quality of the act, and two, the distinguishing right from wrong at the time of the commission of the offense. And the test that's used, or rule that's used in California, is called the McNaughton Rule. Essentially, Proposition 8 reinstates the traditional McNaughton Rule, or insanity, often referred to as the right and wrong test. Now, the McNaughton Rule was in effect since it was first adopted by the California Supreme Court in 1864 until it was overturned by the California Supreme Court in 1978 in a case, People versus Drew. But after Proposition 8, it was basically kind of reinstated, and it is the current insanity test. So the McNaughton test for insanity in California now requires those things that I've been talking about that the defense has to actually prove. Now, there's a couple other things that go along with that. There would be something called burden of proof. Insanity is a defense to a crime. The law presumes every person to be sane and free from mental illness. Now, this means that the burden of proof is in fact on the defendant. The accused person, again, must prove by a preponderance of the evidence that he or she was incapable of knowing or understanding the nature and quality of his or her act, and of distinguishing right from wrong at the time the act was committed. Again, it is the defense's responsibility to prove an inability to distinguish right from wrong. Now, what about that thing that we call temporary insanity? And then we'll get to the final slide or two that we're looking at here. Well, we've heard that before. What about temporary? I mean, and is there a temporary insanity? Can you only be kind of insane for a little bit or a certain amount of time? Well, legal insanity of a short duration, or temporary insanity, if existing at the time of the commission of the offense, is in fact a fully recognized defense as that of insanity for a longer duration. Now, for drug intoxication to be legal insanity, however, it must be what they call settled insanity and not merely a temporary mental condition produced by the recent use of intoxicants, and there's a case that goes with that. A defense of insanity cannot be based solely on a personality or adjustment disorder or seizure disorder or addiction to abuse of intoxicants and other things like that. So let's finish up with a couple of other defenses, and we'll talk about some of these defenses later on, but we're just going to mention them now. So other criminal defenses to criminal prosecution can be found in other statutory and procedural parts of criminal law, and that would include self-defense, which is kind of self-explanatory. Entrapment, necessity, lawful capacity of office, or legal duty. And again, we will talk about a lot of these later on as we get further into some of the chapters. So again, to kind of wrap up, this is going to finish chapter 4, capacity to commit crimes, and talking a little bit about the insanity defense. Don't forget to look at the student review resources that are at the end of your textbook, at the end of the chapters, that include the terminology definitions, the true-false quiz, the essay discussion items, and also the terminology matching quiz, which I think is just an awesome way for everybody to study. So with that being said, that's going to be it for this week, and I will talk to you soon.